I am reading out of the new Reference Guide to Regulatory Compliance on PDF page 700 in paper page 681, and I'm reading the Bank Bribery Act as it is set forth in Title 18 of the United States Code, Chapter 215. The Bank Bribery Act was part of the Comprehensive Crime Act of 1984. This act was amended in 1985 via the Bank Bribery Amendments Act and was further amended in 1989 and 1990 in the Financial Institutions Reform, Recovery, and Enforcement Act and the Comprehensive Thrift and Bank Fraud and Taxpayer Recovery Act, respectively. This area has been given much legislative attention because of the public perception that corrupted officials of financial institutions were, in large part, responsible for the unprecedented rate of bank and thrift failures during the 1980s. These laws were enacted for the purpose of preventing banks from making poor quality loans or engaging in business transactions because a bank employee received a bribe. The statutes prohibit giving, offering, or promising anything of value to a bank employee with the intent to corruptly influence the employee in connection with a business transaction. It is also illegal for a bank employee to solicit, demand, or accept anything of value from a person in connection with a business transaction. The federal agencies and the Department of Justice have published guidelines to implement the law. The guidelines give some practical direction to banks regarding the implementation and compliance program for the Bank Bribery Act. Requirements, Subpart 1, Letter A, it's a criminal offense to do 1 through 4. This is 1, for any person to corruptly give, offer, or promise anything of value to any person with the intent to influence or reward an officer, director, employee, agent, or attorney of a financial institution in connection with a business transaction, or for an officer, director, employee, agent, or attorney of a financial institution for their own or any other person's benefit to corruptly solicit, demand, or accept anything of value from any person in connection with a business transaction. This does not apply to bona fide wages, salary, and other compensation, any fees paid in the ordinary course of business, any expenses reimbursed in the ordinary course of business. Fourth, federal agencies must establish appropriate guidelines for compliance. The penalties are fines of up to the greater of $1 million or 3 times the value of the thing given, or imprisonment for up to 30 years. If the thing given does not exceed $1,000, prison term of not more than 1 year, fined under this title, or both. Subpart 2, Federal Agency Guidelines. The federal agencies, the Federal Reserve Board, Office of the Comptroller of the Currency, and the FDIC each have published guidelines that give direction to banks in complying with the Bank Bribery Act. Letter A, Internal Code of Conduct, is first discussed. Banks are encouraged to develop a written code of conduct for bank employees. Code of conduct should prohibit any bank employee, officer, director, agent, or attorneys from soliciting for themselves or for a third party anything of value from anyone in return for any business, service, or confidential information of the bank. Accepting anything of value other than wages, salary, or so forth from anyone in connection with the business of the bank. Banks should establish appropriate standards for business practices to cover such things as gifts, outside business interests, or employment that can cause conflicts of interest, self-dealing, or other trading on the employee's banking position. Some exceptions, as listed below, to the general prohibition against accepting things of value may be appropriate to include in a policy or conduct. These things include accepting gifts, gratuities, or favors based on obvious family or social relationships, accepting meals, travel arrangements, refreshments, and so forth in the course of meeting or other occasion when the purpose is to hold bona fide business discussions, provided the expense would be paid by the bank if not paid by another party. C, accepting advertising or promotional materials of reasonable value. D, accepting discounts or rebates on merchandise that are available to others. E, accepting gifts of reasonable value related to commonly recognized events such as weddings, promotions, Christmas, and so forth. And lastly, accepting civic, charitable, educational, or religious awards for accomplishments. Note, the Justice Department guidelines specifically state that receipts of benefits that serve no demonstrable business purpose, such as weekend hunting or fishing trips, or scarce or expensive tickets to athletic or theatrical events are not permissible under the bank bribery statute. Banks should assess what is considered reasonable in their specific geographic area. What is considered reasonable in one area may not be considered lavish in another. Code of conduct should provide that a bank employee is offered or received anything of value beyond that which is authorized. The employee should report it to the designated bank official. Code of conduct should provide for employee disclosures of all outside business interests or employment and should prohibit conflicts of interest. Policy should make it clear that disclosure does not make the acceptance of a gift or involvement in a conflict of interest permissible. Letter B, banks should keep records of disclosures of unauthorized gifts and records of statements of outside business interests or employment and potential conflicts of interest. C, banks should maintain copy of code of conduct. And D, employees should acknowledge receipt of a copy of the code of conduct and should agree to adhere to the code. The FERA penalties under subpart 3 enforcement are as follows. Penalties up to $7,500 per day for violations of laws or regulations. Penalties of $37,500 per day if violations or unsafe or unsound practices are engaged in recklessly or are part of a pattern of misconduct that causes more than a minimal loss to the bank or a pecuniary gain to the parties involved. And lastly, penalties up to $1.425 million per day against persons who knowingly commit a violation and knowingly or recklessly cause a substantial loss to the bank or a substantial benefit to the party.